My dear friends, today we are quickly reviewing the judgment of the Honorable Supreme Court passed in Suo Motu Writ Petition Criminal number 2 of 2020, which is regarding the expeditious trial of cases under Section 138 of the Negotiable Instruments Act. Friends, as you would know, there are 35.16 lakh cases which have been filed under Section 138 of the Negotiable Instruments Act. So since the rate of disposal is far less than the rate of institution of these cases, so therefore there is a great pendency of these cases. The Honorable Supreme Court has tried to give impetus, it has tried to give momentum to the quick disposal of these cases, since these cases normally involve sort of a summary trial. These proceedings are required to be like summary trials instead of a detailed, trial. So therefore, in this, the background of the judgment is the great pendency of complaints which filed under Section 138 of the Act, which has had. Now let's quickly see the headings under which the Honorable Supreme Court has dissected this judgment into. Part A deals with the service of summons. Part B deals with Sections 219 and 220 of the Criminal Procedure Code. Part C deals with the summary trials. Part 4 deals with the attachment of bank accounts. Part E deals with Section 202 of the CRPC vis-a-vis Section 145 of the Negotiable Instruments Act. Part F deals with the mediation part, and Part G deals with the inherent jurisdiction of the magistrate. So let us now quickly go through all these headings one by one. Friends, during the course of hearing before the Honorable Supreme Court, one important aspect that was discussed was regarding the delay in service of summons in these cases. So Mr. Siddharth Luthra, the Honorable amicus appearing before the Supreme Court, has made very stern appeal to the Supreme Court that we should hasten the service of summons, which otherwise consumes a lot of time. If we have to step up the speed at which the court functions to wrap up the 138 matters. So towards achieving these goals, he has expressly suggested and advised that the dishonor slips which are issued by the banks should reflect the current mobile number, email ID and the postal addresses of the drawer, so that if a person readily has this information before him, then it becomes all the more easy to serve summonses on an accused. Secondly, he has also given a suggestion that there should be a nodal agency which should be created for electronic service of summons. Thirdly, he has suggested that a unique number should be generated in the dishonor memo itself, so that the accused can be quickly served upon. However, the Honorable Supreme Court has desired that a committee under the chairmanship of Mr. A.C. Chauhan, the retired Bombay High Court judge, has been formed, in which he would be a chairperson, and this committee shall look into all these suggestions that have been put through by the learned amicus. This committee, among other things, shall also deliberate on the need for creation of additional courts for trying the offences under Section 138 of the Negotiable Instruments Act. Friends, in the later part of the judgment, the Honorable Supreme Court has dealt with Sections 219 and 220. In fact, they have, if you would have gone through Section 219 of the CRPC, it deals with such a situation where a person is charged with certain same kind of allegations, same kind of acts have been committed, similar kind of offences have been done by him within 12 calendar months, then all such offences can be tried together. He can be charged with and tried at one trial for all such offences. But the maximum number of charges, the maximum number of offences that he can be tried for, it should not be more than 3. Section 220 is a little different. It lays down that in case there are a series of acts connected together to form a same transaction, then no upper limit has been prescribed. In such a case, a person can be tried for all such acts in one go. So precisely there is the difference between 219 and 220 is that whereas in 219 an upper limit of 3 has been given, in 220 no such upper limit has been given. Now the issue in the check bounce cases, insofar as 138 cases are concerned, is that, say for instance, if a person is regularly a defaulter and is committing the offences under section 138 on multiple occasions, like he's doing it 10 times or 15 times or 20 times in a calendar year, then because of the bar of section 219 CRPC, he cannot be charged with and tried for all such offences in one go, unless and until all such offences are until and unless all such offences qualify to be acts connected together so as to form a same transaction. So therefore, in such a scenario where a person is asked, where a person can be charged with and tried for only 3 offences at the maximum, so the Honorable Supreme Court has placed this question before the committee that I have already discussed about. Additionally, in order to reduce the time of trial for all the cases involving section 138 of the Negotiable Instruments Act, the Honorable Supreme Court has directed, has made another very beautiful direction. It says that in order to reduce the time limit spent on service of summons, in case a person is charged with and process has been issued against him for any number of offences committed by him, as discussed under section 220 of CRPC, then in such a scenario, even if in one of the complaints he has been served, then he will be deemed to have been served in such other complaints as well. So that is going to save a lot of time. Say for instance, if a person committed an act of section 138 on multiple occasions, and multiple acts, they were connected together so as to form a same transaction, then earlier on he had to be necessarily and mandatorily served in each of such complaints. But now, by virtue of this direction of the Honorable Supreme Court, even if he is served with properly, in one of the complaints he's been served with, then he will be deemed to have been served in all the complaints that I have discussed. In the finishing paragraphs of the judgment, the Honorable High Courts have been directed that they should identify all such criminal revisions in which offences under section 138 of the Negotiable Instruments Act are committed. Even in criminal appeals where the subject matter involves check bounce, over there also such cases the High Courts have been directed to to identify such cases and to ensure that all such cases are sent to mediation for resolution at the earliest. Then another aspect that has been touched by the Honorable Supreme Court in this judgment is the application and operation of section 202 of the CRPC versus the provision section 145 of the Negotiable Instruments Act. Under section 202 of the CRPC, the magistrates and the courts have been asked to hold an inquiry before issuing a process against the accused. So therefore, the magistrate is required by virtue of section 202 of the CRPC to make an inquiry into the offence, the gravity of the offence, so that he satisfies himself after conducting an inquiry into the issue that there exist sufficient reasons to proceed against the accused. However, as far as section 145, now one important aspect of section 202 is that it requires that a person should be examined on oath. However, under section 145, this particular condition has been dispensed away with because section 145 lays down, after the 2003 amendment, that a person can be examined even on the basis of the affidavit tendered by him. He need not be examined on oath. So therefore, the Honorable Supreme Court says and ratifies and states that it is sufficient if a magistrate satisfies himself on the basis of the affidavit on record and the documents on record that reasons exist for issuing a process against the accused under section 138. So therefore, a magistrate is not required to examine the witnesses on oath as specifically mentioned under section 202 CRPC, because section 145 lays down, section 145 of the Negotiable Instruments Act lays down an exception to the general rule.